manipulation of benchmark oil prices. And third, but certainly not least, we would not be here without our partners. I would like to thank the U.S. Attorney's offices for the Southern District of New York and Connecticut, the FBI, and the U.S. Postal Inspection Service, who worked to unravel these schemes alongside Criminal Division prosecutors Layla Babaiba, James Mandovo, Avi Perry, Matt Sullivan, John Leolas, and Michael Koo, and our Office of International Affairs. We coordinated effectively with our partners at the CFTC, which resolved its enforcement action against Glencore earlier today, and we coordinated effectively with the UK's Serious Fraud Office and the Brazilian Ministério Público Federal, which both also resolved their proceedings with Glencore earlier today. We'd also like to thank the Swiss authorities as partners in the global fight against corruption. Just last month, the SFO director hosted a meeting to reinforce our shared commitment to tackle transnational crime. Our robust partnerships give criminals fewer places to hide, and you have my commitment. Our criminal division will continue to vigilantly pursue difficult and impactful cases in the months and years to come. I will now turn the podium over to my friend and colleague, U.S. Attorney Damian Williams of the Southern District of New York.
Thank you, Kenneth. Good afternoon. My name is Damian Williams, and I am the U.S. Attorney for the Southern District of New York. The criminal charges filed against Glencore in the Southern District of New York are another step in making clear that no one, not even multinational corporations, is above the law. The scope of this criminal bribery scheme is staggering. For more than a decade, Glencore cheated the free market to gain a competitive edge. Glencore paid over $100 million in bribes to government officials in Brazil, Nigeria, the Democratic Republic of the Congo, Venezuela. The bribery scheme here spanned the globe. Glencore paid bribes to secure oil contracts. Glencore paid bribes to avoid government audits. Glencore paid bribes to judges to make lawsuits disappear. Why did Glencore do it? They did it to make money, hundreds of millions of dollars, and they did it with the approval and even the encouragement of top executives. And as we allege in the charges filed today, Glencore tried to cover up the bribery scheme with code words and bribes paid through third-party consultants. It didn't work, because Glencore ultimately could not hide from the prosecutors at the Southern District of New York and the Department of Justice. Let me be clear. Much of this expansive bribery scheme was made possible because Glencore's control environment was entirely inadequate. Bribery was built into the corporate culture. When we investigate and prosecute corporate crime, we often discuss the tone from the top. In this case, the tone from the top was clear. Whatever it takes. Well, no more. I want to thank the career prosecutors in my office who are handling this case, Michael McGinnis and Juliana Murray, and their supervisors, Christopher DeMacy and Sagar Ravi, the chiefs of the Complex Frauds and Cybercrime Unit. This is the third major corporate fraud case that the Southern District of New York has brought in recent weeks, and the second corporate guilty plea in the last 2 weeks. And I'm going to repeat what I have said before. The Southern District of New York is going to be relentless in rooting out corporate corruption, whatever it takes, wherever it lies. And just because you are abroad does not mean you are out of sight. We're watching. I'd now like to turn the podium over to my colleague from Connecticut, U.S. Attorney Vanessa Roberts-Avery.
Thank you, Damian. I am Vanessa Roberts-Avery, United States Attorney for the District of Connecticut. Glencore's market price manipulation threatened not just financial harm, but undermined participants' faith in the commodities market's fair and efficient function that we all rely on. This guilty plea and the substantial penalty incurred is an appropriate consequence for Glencore's criminal conduct, a significant component of which occurred in Connecticut at its offices in Stamford. We are pleased that Glencore has agreed to cooperate in any ongoing investigations and prosecutions relating to its misconduct, and to strengthen its compliance program company-wide. The U.S. Attorney's Office in Connecticut has long been committed to vigorously and fairly enforcing the laws applicable to corporate entities doing business in our district. I thank our partners at the U.S. Postal Inspection Service for their hard work and dedication in investigating this sophisticated set of facts and unraveling this scheme. And I especially want to recognize the fraud section, with whom we look forward to continuing a full and fruitful partnership in prosecuting these complex financial and corporate criminal cases. Lastly, I want to thank the career prosecutors in my office who have labored tirelessly on this case. David Novick, who is the chief of our Financial Frauds and Public Corruption Unit, and Assistant United States Attorney Jonathan Francis. I will now turn the program over to the chairman of the Commodities Futures Trading Commission, Russ Benham.
Good afternoon. Thank you, Attorney General Garland, and all of our law enforcement partners for working closely with the CFTC after we brought this activity to light. Today, the Commodity Futures Trading Commission resolved charges against Glencore International AG, Glencore Limited, and Chemoil Corporation. The settlement represents the largest settlement in CFTC history. Glencore is one of the world's largest commodity trading firms and a major participant in the global oil markets. The deceptive and corrupt conduct was deliberate, it was longstanding, and egregious, in that it involved a concerted effort by individuals at all levels within the oil trading group, including its most senior leadership, to undermine the pricing mechanisms on which trillions of dollars of financial derivatives contracts, which the CFTC oversees, are based. Glencore's conduct included manipulating or attempting to manipulate publicly available price benchmarks for multiple fuel oil products. Glencore's manipulation was intended to alter and influence benchmarks to benefit Glencore's financial and physical positions and to increase profits to the tune of over $320 million. When individuals and entities seek to disrupt the reliability of benchmarks, they interfere with the proper functioning of the markets that directly impact consumers. Without question, manipulating oil markets can drive up the cost Americans pay at the pump or to heat their homes. And today, my message to the markets is clear. The CFTC will continue to pursue even the slightest hint of manipulative, corrupt, or fraudulent behavior. I want to commend the incredible work of Gates Harand, Peter Janowski, Jacob Mermelstein, David McGregor, Stephen Painter, Michael Kazikoff, Matthew Edelstein, Patrick Marquardt, Jordan Grimm, Linnell Hickson, and Manal Sultan. I want to thank the Department of Justice's Market Integrity and Major Frauds Unit, the Department of Justice's Foreign Corrupt Practices Act Unit, and the assistance of all our law enforcement partners in Brazil, Bermuda, Hong Kong, Luxembourg, Mexico, and Uruguay. The CFTC is focused on ensuring the transparency, the credibility, and the integrity of commodity markets. Where wrongdoers seek illicit gains through interference and manipulative practices, the CFTC will be thorough, aggressive, and unrelenting in our response. Thank you. And now turn it over to Brian Turner from the FBI.
Good afternoon. I want to congratulate the International Corruption Squad and our New York field office for their successful investigation. This 5-year investigation spanned the globe, and today's results highlight the importance and necessity of cooperation with our foreign law enforcement partners. Over the course of our investigation, we uncovered how Glencore paid more than $100 million in bribes to officials in more than a half-dozen countries. Foreign bribery has the ability to impact U.S. financial markets, economic growth, and national security. It also breaks down the international free market system by promoting anti-competitive behavior and ultimately makes consumers pay more. What's even worse is that Glencore's bribery payments were primarily in developing nations whose citizens were the ultimate victims of the bribery. When those officials accept bribes in their official capability for personal gain, they are betraying the trust of the people that they represent, which ultimately breaks down the global order. And businesses that pay bribes continue the cycle of corruption within the governments of those developing nations. The Foreign Corrupt Practices Act exists to stop these practices from happening. We in the FBI take these crimes very seriously, and we're committed to shining a light on corruption wherever it exists. Today's results send a message that even the largest, most well-known, and most successful international companies will be held accountable for their corrupt and illegal behavior. I'm now going to turn it over to my colleague, Craig Goldberg, Deputy Chief, U.S. Postal Inspection Service.
Thank you, Brian. Good afternoon. My name is Craig Goldberg. I'm the Deputy Chief over our criminal investigations with the United States Postal Inspection Service. The idea of fair and honest trade is the bedrock of American commerce. And it's an insult to our shared traditions and values when individuals or corporations use their power, wealth, and influence to stack the deck unfairly in their own favor. Manipulating the price of essential commodities for personal gain is not only illegal, it also damages the integrity of international commerce. And it erodes public confidence in our supply and demand market economy. That's why the Inspection Service's mail fraud team, embedded at the Department of Justice, and the Market Integrity Major Fraud Section of DOJ joined forces to combat illegal manipulation in the commodities market through the Market Manipulation Initiative, or MMI. This case is an excellent example of the MMI's success, and yet it is only one of several currently under investigation under the MMI. To date, 7 of those cases have yielded 5 arrests, 3 indictments, 1 guilty plea, 2 convictions, and millions of dollars of forfeiture, criminal fines, and penalties. Results like these prove that we can accomplish great things in the law enforcement community when we work together. I want to thank Attorney General Garland and the Department of Justice, the FBI, the Commodity Futures Trading Commission, all the U.S. attorneys' offices that we worked with, and all of our other partners who contributed to this investigation. Our work together and the results announced today demonstrate our combined effectiveness. They also showcase our tenacity in holding accountable criminals who try to enrich themselves by undermining the forces of supply and demand. Thank you very much.
All right, with that, we'll take a few questions.
Sure. Thank you for doing this. So I have 2. For one, you said that the Justice Department wants to and plans to hold individuals accountable for corporate crime, but in the FCPA case, there's only been 1 middle manager charged. Why are we not seeing more individuals and more executive charge in this case specifically?
You're exactly right. We take holding individuals accountable priority because this is the way to deter corporate crime, because it's the individuals who will end up paying, and because it is the individuals who are responsible. In this case, there are 2 guilty pleas of individuals. Just last week, in another case, there were at least 1 or 2 others. And I'm going to pass on to the head of the criminal division. I'm unable to talk about any pending investigations, however. So I'm.
Real quick, while I have you up here, though, okay. I do want to hear your answer.
Hey, that makes 3, Cindy.
No, it's 2. But just while I have you here, I just am wondering. You know, you imposed a moratorium on executions. I'm wondering if, from what you've seen so far of the Buffalo grocery store shooting, if this is a case that would represent one in which you would consider seeking the death penalty.
So charges for the federal government haven't even been filed, so we're not at anywhere near the stage where that occurs. As you know, there's a process, I think, set up originally by Jana Reno for developing a record on that subject, so really can't say that. Before we switch over there, do you want to answer this question?
Yeah, so tell us about the individuals.
Sure. Thank you again, sir. And the question goes to, as you noted, there's been 2 guilty pleas, 1 in each of these components of this prosecution. Mr. Stimler in the FCPA case, Mr. Heredia in the commodities trading case. They are individuals that have significant culpability in the underlying misconduct. With that said, we will not comment on ongoing efforts to hold additional individuals accountable. These are complex cases, particularly when we have global partners where individuals may lie outside of the United States. We do coordinate with our law enforcement partners across the globe to ensure that those individuals are held accountable wherever they may sit.
General, I hate to go off topic here, but we're getting word.
No, you don't.
We're getting word of a possible shooting at or near an elementary school in Texas. Can you give us any update on whether there are injuries or fatalities?
So, Pierre, I was just briefed on this as we were walking in here. We will put out information as soon as we know more, but I'm not able to say anything right now. Sorry.
Mr. Attorney General, you talked about having monitors go into this company. Can you talk, well, what are these monitors going to do? Are they going to be coordinating with the Justice Department, and how and what if they're finding out that the company isn't following through with this obligation? And then I have a quick follow-up question.
All right. That question, which is a very good question, I'm going to ask the Assistant Attorney General to give you the specifics on. If you want the follow-up question, I'll be happy to start with that, and then I'll switch over.
Okay. Former Attorney General Eric Holder has said that it appears there's sufficient evidence to indict former President Trump for the actions in the days and weeks leading up to January 6th. As one Attorney General to another Attorney General, how do you respond to Mr. Holder? And what do you say to Americans who are looking at what happened in the days, what we know publicly already about what happened in the days and weeks leading up to January 6th? In our questioning, where are the charges for those activities?
Look, normally when I answer this question, I say the Justice Department has a long-standing policy of not commenting on pending investigations, whether they are pending or not. I think it's fair to explain why that's our policy. So it's our policy for three major reasons. First of all, it protects the civil liberties of people who have not been charged. This is critically important. That we not begin making comments outside of the record of charges. Secondly, it protects the civil liberties of people who have been charged. As you no doubt know, there are 800 cases already brought against individuals with a broad array of kinds of charges, making statements about others, making statements about pending investigations outside of theirs, can affect theirs, and it can also make it more difficult, our own prosecution in that respect. And finally, Justice Department investigations typically proceed in relative secrecy. Things come out as we file papers, as we file search warrants, as we file for orders, as we file charges. If we let all possible witnesses know exactly where we are at exactly what moment, it makes us very difficult to do our job of ensuring that the laws are not violated and that those who are accountable are brought to justice. So that's the reason I give the short form answer. I know a lot of the members of the press corps here hear it a lot, and I know that they know that, but I think it's important for me to say more generally. Now, you had a question which I've almost forgotten, but I think belongs to Mr. Polite.
Yes. Thank you, sir. As to monitors, look, and I reflect this coming from my background as a prosecutor, but also as a former chief compliance officer. We make the decision to impose monitors in two separate cases. One, when we find that corporations have not properly resourced their compliance function, or, and this happens quite frequently, when they have not had the opportunity to properly test that compliance function. Even if they've resourced it, if they haven't had the opportunity to test it to prove that they've had the resources, the policies, the procedures, the controls in place to ensure that misconduct is detected, remediated, and ultimately prevented, that will also be a situation where a monitor is appropriate. Monitors oftentimes will be then responsible to work with that corporation to ensure that it is actually making that appropriate investment in its compliance function. But more importantly, it's also reporting back to the Department of Justice any findings that it makes related to a lack of investment or to additional misconduct that may be occurring in the company.
Hi, Stefania Farmer, the Financial Times. In light of what you just mentioned on the compliance monitors, could you comment on, or perhaps it's both of you, could you comment on the compliance controls that actually were set up by the former Glencore CEO, Evan Glasenberg? Were they tough enough? What type of understanding do you have about how the company tried to improve them, and therefore what kind of role will these monitors play? And secondly, very quickly, you have taken action against VTOL in the past. Now this settlement with Glencore, are there other commodity traders in your sights?
As to your second question, listen, this is an area that we're remaining vigilant in, but I will not be in a position to comment about other actions that we may be taking. As to the first question, though, the significant level of investment that a company has made, we certainly take that into consideration in fashioning the appropriate resolution here. Certainly, it is the type of investment that we credit. With that said, my prosecutors and our law enforcement partners ultimately determined that that level of investment was certainly not high enough, or that it was made at a late enough time that it was not at a position where it had been properly tested in this particular circumstance. And so we did believe that it merited the imposition of not one, but two separate monitors in this particular resolution.
Thank you.
Thank you.